Okay. Hello, welcome. We're your lunch entertainment. Keep eating. We're just here. I'm James Cooper. I'm a professor of law here at Antonin Scalia Law School. I'm also the director of the program on economics and privacy, which is a division of the Law and Economics Center. I'm thrilled to be here with an esteemed panel. We're here to talk about privacy and antitrust. So privacy and antitrust have been on a collision course for a long time. You can maybe take it back to 2007 with the Google DoubleClick merger, where at that time Commissioner Pam Harber and Tara Kosloff wrote an article in the Antitrust Law Journal about data markets. In fact, I was reminiscing with Danny. In fact, over a decade ago, for this very symposium, I wrote a piece called "Privacy and Antitrust." So here we are. We're still talking about it. I think that this collision course that we've been on has probably finally happened, and in many ways, it seems natural. I mean, ad-supported tech firms that don't charge anything and use information about their consumers to serve ads and to customize their offering. They've also become super important, as we just heard in the last panel, in the antitrust world, right? So you've got, right now, the Department of Justice has 2 cases against Google the last time I counted. I don't know if anything's happened since I've started the panel. The states have the states have a case. The FTC has a case against Facebook. And if you read the allegations of these complaints, many of these complaints they have allegations about the impact on privacy. It's not the only thing, but privacy is front and center. Now, this is so what once was the realm of just academics seems to be real in the real world now. So what we want to talk about today is, how the tools of antitrust are going to translate into this into this world of tech platforms that don't charge anything, how does antitrust translate into that? There's also another side of this, and it's how does privacy regulation impact competition? And we'll get into that as well. We heard a little bit about that in the prior panel about the DMA. And it's not surprising that when we have privacy regulation, privacy is about restraining information in many ways, and information is very important to making markets work. So if privacy regulation is about husbanding information, it's not surprising that privacy regulation can have an impact on competition as well. So with that as kind of an introduction of what we're going to get into, as I said, we have an all-star panel. You can look at their full bios. I commend you. They're all super accomplished and well qualified to be up here. But I'll just give a brief introduction. Starting at the end, Koren Wong-Ervin, she's a partner at Jones Day and has also served at the FTC in the Office of International Affairs in a prior life. Ramsi Woodcock is the Wyatt, Tarrant, and Combs Associated Professor of Law at the David J. Rosenberg College of Law at the University of Kentucky. Andrew Stivers, next, is Director at NERA Economic Consulting, and he is the former Deputy Director for Consumer Protection in the Bureau of Economics at the Federal Trade Commission. That's a mouthful, but I did it. And we're former colleagues. I had the pleasure of working with Andrew for a year while I was back at the FTC. And then finally, last but not least, to my left is Danny Sokol. Danny is a Carolyn Craig Franklin Chair in Law and Professor of Law and Business at the Gould School of Law at the University of Southern California. And
the Marshall School of Business.
And the Marshall School of Business. Thank you for...
No, but that's what matters because, we're always told self-preferencing is bad, but I'm really thrilled about my new innovation this semester, and I want to see this class replicated everywhere. It's called Innovation, Economics, and Business in Beer, AI, and Video Games. Case-based class for business school students. You teach all the major issues, strategy, marketing, operations.
All right. This is GMU's platform, so I'm shutting it down. I may face a,
No, you need to
lawsuit
have
at
it
some point.
here. You need to have it here. Law students,
But
you want to
no advertising rival schools on this platform.
Wasn't a
okay?
law class.
All right. So let me, and that wasn't planned. This is like Curb Your Enthusiasm up here. This sort of this sort of ad-libbing here. So let's start off. I'm gonna kick things off with kind of the big picture question here to Koren. And, just kind of big picture, does privacy even have a role in competition analysis, or is it really just best left to consumer protection? And I guess if the answer is no, it has no role, then we're done and we can go back and eat lunch. But I'm fingers crossed that you have a more nuanced answer to that.
I do. And thank you to George Mason and the organizers for inviting me. I am especially honored to be on a panel on privacy and antitrust with James because I think of James as one of the foremost experts when it comes to it. And probably everything else I've learned and much of what I'll say today, I've learned from reading his articles and also with John Yoon. So, if the question is, does it as opposed to should it, then yes, it does. And we've seen that around the world from competition agencies in their cases and public statements and priorities. If the question is should it, then I think that yes, it's theoretically possible that we could have an economically sound antitrust case. But because of some complications I'll talk about, I think that it's likely pretty rare, especially in the unilateral conduct context. So the fundamental kind of underpinning of all the different theories that I've heard, or most of them, is that privacy as quality, right? And again, there's a nice paper that James and John Yoon wrote kind of going through all the problems with this analogy. And I'll just talk briefly about a couple. The first is that unlike if you just have a poor quality car, when consumers are revealing their data, they generally are getting some benefit from that, right? They're getting some better quality products, getting advertisements that they actually care about, or even because it's allowing companies to have a revenue stream, they're getting zero price products or goods. And so that offsetting benefit needs to be taken into account. The other thing is that the privacy paradox, which we've all heard about, right? The difference between revealed and stated preferences. So the difference between things like what consumers say when they're asked in surveys, do you care about, do you want privacy, versus the trade-off that they actually take in real life and how they actually behave. Another thing is that the value that consumers place on the different trade-offs, the benefits and costs, vary throughout the population. And so it's difficult to sort of identify where is there a lessening of competition, right? Instead, we can think of this more properly, I think, as product differentiation as opposed to some kind of unlawful exercise of monopoly power. And so I started with saying that, I think it's even more difficult in the unilateral conduct context. I think that even if we were to completely set aside these problems with the the privacy as quality analogy, then I could possibly see a case in the merger context, right? But when you're talking about unilateral conduct, then at least under US law, our Supreme Court is very clear that a monopolist can charge the highest price or set the lowest quality that the market will bear, right? That you need some type of exclusionary or predatory conduct. And so there is one kind of conduct that I've heard about, or maybe more than one, but one of them is the predatory privacy policies, right? The idea that a company fraudulently misrepresents the privacy that it's going to have, and then that results in unlawful acquisition of monopoly power. And so in this case, I think, the fraudulent misrepresentation would need to be material, need to actually shift demand, and it would also need to be durable, right? It actually has to, not be discoverable, or if it is, once if consumers realize it, they can't switch. And we have some case law on this in other contexts. The DC Circuit's Rambis case, which requires, but for the deception, then consumers would have chosen a different platform or a different service. And, I think it's even maybe easier here because in the Rambis case, we were talking about patents that were essential for a standard, right? And here it would be consumers not being able to switch away from, a social media platform. It's not the same as a standard. I think one other thing that we'll talk about later in the panel is privacy as a defense. Both companies explaining that they need to restrict data from rivals because to be able to comply with the privacy law, and then also relatedly, sort of that it's a pro-competitive or legitimate business justification for conduct. And there's some interesting issues here, including out-of-market efficiencies and what we mean by an efficiency that protects the competitive process, but we can get into those later.
Well, thanks, Koren, for doing a great job setting the stage. I want to give the other panelists kind of a chance to weigh in also on this bigger picture question and drill down a little bit. If privacy does have a role in competition analysis, there are really two broad ways we've seen this raised. One has been that privacy should come directly into the competition analysis. For example, I'll use an example, the Google Nest merger, which raised zero competitive concerns. FTC, cleared it, no problem, for a variety of reasons. But nonetheless, there was a push to block the merger because it would be allowing Google to have more data, and it would raise a privacy problem. So you should use antitrust to block a merger that would potentially have raise privacy issues. That's one method. The other method would be you find actual competition over privacy. And so I guess I'd open it up. I don't know, Danny. How do you feel about
I was
those
just nodding.
two?
I was kind of hoping that you'd go down.
Okay, well, I'll go down the line. So Ramsi, I'll make Danny wait. So Ramsi, what do you think when you look at that sort of division between how some people have seen let's use the antitrust laws to get the privacy we want, regardless of the competition problem, or should it just focus only on competitive concerns? Should it be broader?
So these are great questions, and just before answering them, I just want to acknowledge that we're living through a very special moment in our nation's history. Our government is currently committing genocide in Palestine through the colony we maintain called Israel. We have killed 30,000 people so far and nearly 15,000 children, and that must stop. Now, to answer your question, I think there's really only one way we can deal with competition concerns surrounding privacy, and that is through the consumer welfare standard. So there's a temptation to bring privacy issues in as a kind of independent value in antitrust. And of course, we cannot do that because if we import privacy in as an independent value, why not import any number of other considerations as independent values into antitrust as well? So we must go through the consumer welfare standard. And so I think that the FTC's approach is somewhat misguided. The way to think about privacy in terms of antitrust is by looking at the way we treat any other value, which is what its effect is on consumer welfare. What matters is what consumers believe is important in their purchase decisions. And so we've seen that consumers don't care much about privacy. They don't tend to opt for services that protect their privacy the most. And they've been very well educated about this issue over time. I think the main way in which privacy should become part of a competition law analysis is through advertising. So the reason why we care about privacy as consumers is generally because our information is used to create targeted advertising that can potentially manipulate us. There's two general theories regarding advertising. One is the ascendant informative theory, which says that advertising is primarily informational. The other is the manipulative theory of advertising, which was very prominent and respected by antitrust enforcers up until the early 80s with the Chicago Revolution. And that holds that advertising can cause consumers to buy products that they don't really prefer. And so when they do that, you have an efficiency loss, right? And you have harm to consumer welfare. In effect, consumers end up paying higher prices for products that they value less as a result of advertising. And so a lack of privacy can make that advertising more effective and therefore cause them to suffer greater harms. And so this, I think, is really the main way we can deal with privacy as a competition law concern.
So Andrew or Danny, do you want to weigh in?
Yeah, just very briefly, there's a number of issues related to privacy that I think are firmly in the antitrust analysis. If you look at the vast amounts of data that many of the large firms that have been subject to investigations have amassed, access to that data, which, as it happens, is often about consumers, can have antitrust implications, right? If there's essential data that you can't compete without, that kind of thing. But that's like an old traditional antitrust kind of analysis. So that's firmly within antitrust as it's been done for a while. But I think that is the confusion has been that's not really privacy. That's data. That's an asset. If we think about privacy and whether privacy itself should be part of the antitrust analysis, I do think that's largely going to bring in a variety of things that haven't traditionally been part of that analysis. I would argue they're still part of consumer welfare. I may carry very deeply that large firm A doesn't have access to my data, but I care less that smaller firms B through Z have access to my data. I might have preferences about that. That's going to affect my consumer welfare. That's not traditionally been a part of our antitrust analysis, sort of societal preferences for how data is distributed. But it is potentially, it is a privacy preference for some people. So there's a whole variety of actual privacy, directly privacy related things that people do care about that are new. And I think that going back to some of the comments, the previous comments, there are other tools, regulatory tools for dealing with that. It's not clear to me that the best way to make progress in addressing some of those issues is through antitrust.
Danny? Yeah.
Sure. Let me just begin with the general disclosure. I'm full-time academic, but one day I work for a law firm. I've done work for big tech, against big tech, for and against companies that are big in tech, but not necessarily big tech, and for industry associations. So let me actually take a few of these points. So I want to go back to the George Mason tradition beyond you for just 1 second. So Tim Muris, who's absolutely brilliant, some 20, 25 years ago, really focused on the complementarities between antitrust and consumer protection generally. We saw very prominent GMU law grad Maureen Olhausen, specific to the privacy side, basically make a similar point of complementarities. I think while this is generally true, because this is what we focus on in the world that we most live in, sometimes there's complementarities, sometimes we don't have any overlap, and sometimes they're in tension. And we see this in other areas of law where there are complementaries that have nothing to do with antitrusts. Say, M&A corporate law versus M&A tax law, contract law versus tort law. They're not all the same. We can see the same kind of mechanisms at play. And the hard part is always trying to figure out which bucket does it fit in, because there's always someone who says, it fits in my bucket because that's what I know, and that's the tool set that I know how to deal with. So here, I think the answer is it depends, but it depends in a number of ways. So the first question is sort of, and this, I think Maureen was really good at trying to figure out, does it feel more privacy or does it feel more antitrust? But I'd actually say it's even more complicated than that, because here we are talking specifically about privacy. You're talking about end consumers and privacy. Some of these same issues manifest themselves in broader data protection, data security that might involve industrial data. And the question is, do we have the same kind of reaction outside of pure consumer privacy? Or is there something distinctive in this particular setting? Again, I think the answer is it depends, but this is sometimes also forgotten that these are tough questions, and ultimately it depends on the fact-specific situation and how we apply our tools. Do we believe in privacy in the United States? Actually, different co-author, but I like talking about other people's work, so I'm going to do that my class, but other people's work. Let's imagine your name is Jeff Prince at IU Bloomington, who actually has wonderful empirical work looking at different countries have different views on how important privacy is. So it's not going to surprise you that Europe cares a lot more about privacy than we do. We don't need this study, actually. You just need to know that we're in season 16 of The Real Housewives of Orange County, and to know that we don't care about privacy. But in some areas we do care about privacy, and sort of when does it matter on the competition side, and how does it play out? And again, it depends, because a lot of behavior has a lot of set of trade-offs. So if we look at the empirical work, I'm going to talk about other friends / co-authors. So Anindya Ghosh at NYU for 15 years has been doing really tremendous work looking at value creation for targeted advertising. So clearly it does matter in some cases, and it's producing more benefits than harm. Then I'll talk about my own colleague Tianshu Sun, who's done the same type of work. But there's a long empirical literature showing, for the most part, a lot of value creation. Does that mean that we shouldn't be taking a look at this? Absolutely, we should be taking a look at it. I mean, like, each case is interesting and special. Google Nest, probably not that case. But there are other cases where, it's real, and sometimes it's sort of framed as privacy, but in fact is a traditional competition law, antitrust type case. I say competition law because we're hearing a lot about Europe.
Yeah, we want to be Europe.
Some more than others. I'll just leave it at that.
Okay, well, thanks, Danny. Oh, so if we're, I'm going to turn to Andrew now for the next question, kind of leading us down this path. I mean, if we're going to think about, and I don't want to put words, I mean, in the panelist's mouth, but I mean, I think I think there was a consensus that, okay, well, there are lots of things that impact consumer welfare, but are outside of the realm of antitrust because there's no causal link between lack of competition and that. I mean, the Supreme Court's been pretty clear on that. And I think that I heard that from everyone that, like Danny said, the Google Nest, okay, so now Google has some more data. There's no competitive problem. Let's block this merger nonetheless. That's probably not the place to do it. But if we're going to focus on areas where there is, say, competition over privacy, and Andrew, I'm going to point to you. I mean, is that a real thing? And we heard a little bit about this with the privacy paradox. Koren talked about that. It's theoretically possible. You could imagine two firms going at it and competing. I have a better privacy policy. No, I do. In the idea that it's like quality, but so kind of a two-part question to you, Andrew. One, is competition over privacy a real thing? And kind of related to that, how big of a deal does it have to be before it becomes a competitively relevant thing that we should care about in antitrust law? In the sense, I think about an example, like I care about cup holders in my car, right? But you don't see firms really, when they're putting their auto ads on, caring about cup holders. And we think about a merger between two automakers where the competitive problem is going to be that, well, we think there'll be less cup holders because these firms used to compete really fiercely on the number of cup holders in the back seat. And now there'll be one fewer, maybe. That's our prediction from our, so maybe that's an absurd example, but at what level does it have to be relevant to be a competitive problem?
Yeah, that's a great question. So I think, as James suggested in the introduction, we may have kind of hit peak privacy antitrust kerfuffle in the sense that I think a couple of years ago, all of the agencies and all the attorneys I were talking to were like, oh my gosh, antitrust and privacy, something, right? And I think we've gotten beyond that. We've gotten beyond that. Like people have calmed down a little bit. But is there a nexus between competition and privacy? Does competition drive privacy? In general, no, it doesn't. I'll talk a little bit about why. And part of that is because competition feeds on information, right? If I'm trying to, and this was alluded to in the point about advertising, if I'm trying to find customers, I really want that information. There's some really interesting theoretical work, and there's some empirical work too. There's interesting theoretical work that suggests that the highest prices in a duopoly market are going to occur with sort of partial information. Because if I have partial information, I may know enough to be able to figure out who's closest to me that I can, their travel costs to somebody else or their costs of buying from somebody else are really high, so I can extract their surplus. But I don't have enough information to go after my competitors' kind of favored clients, favored customers. If we reduce privacy, then suddenly I figure out ways to compete for everybody. So every customer potentially becomes a contested customer, and so we can increase privacy. So there's some very interesting subtleties in terms of how information, how privacy affects competition. But in general, if you reduce the amount of information that is available to firms, you're going to get less innovation. You're going to get less competition to try to search for and serve the customers that you want. That's sort of on the supply side. On the demand side, we see a couple of different things going on. First of all, as again was alluded to, people's privacy preferences are quite idiosyncratic. The Economics of Privacy paper that was published by Alessandro Acquisti and Liad Wagman and Curtis Taylor. Thank you. No, sorry, Curtis. I've met the other two. I haven't met Curtis. It's a seminal paper. If you haven't read it, you should. It's a great paper. But one of the central points there is that people have different, even within the same person, we have different preferences about privacy depending on the situation. When I'm trying to find a mortgage, I have very low preference for privacy. I want those mortgage companies to know how great my credit is. If I'm, trying to get the best deal on, I don't know, the dog that I'm trying to new dog that I'm trying to buy, I want to be like, oh, dogs are okay, but I don't want necessarily people to know how much I would value that particular dog. So it's going to vary a lot. On top of that, there's a bunch of market failures that I think most of us are aware of in how firms could compete over privacy that really get in the way of that. One of those is going to be information asymmetry, right? A firm knows a lot about what it's going to do with its data. All you know is that you're, navigating to a particular site, looking at a bunch of stuff, making a final choice, agreeing to a particular price. You don't know where that's going to go. And so how is it that I'm going to make decisions about where to shop if I don't really have any idea about what's going to happen to that data? Maybe I care, maybe I don't, right? The idiosyncrasy problem. But I don't know what the effects are, and I don't know how to use that in a competitive environment. There's externalities, and some of that has to do with that asymmetric information and the attenuation of the effect between my sharing my data and some potential effect from it, right? So because there's not that direct effect, firms can just kind of ignore that cost to people. It could very well be, and there's been plenty of anecdotal cases where people have been severely injured or harmed by the proliferation of their data. But understanding at any given point what that link is going to be is quite difficult. And people make mistakes. There's the apocryphal story, I think a potentially apocryphal story of Target sending prenatal vitamins to a teenager and therefore outing her as pregnant to her family. one of the lessons of that story is Target absolutely would not have wanted to do that if they had realized, if they had sort of full information and realized kind of what the effect was going to be. So that failure to link all of the potential costs of collecting the information, using that information with the potential outcomes, is going to make it hard to compete on these things in an effective manner.
Well, thanks, Andrew. So let me open up kind of this question about to what extent is privacy competitively relevant? Koren, Ramsi, or Danny, you guys want to jump in on here at all?
I'd be happy to just kick it off. So, I mean, we don't really even know what we mean by privacy, do we? If you think about, Andrew just gave this really interesting account of it that got me thinking that, there's a kind of spectrum where maybe ideally what the consumer wants is sort of complete control over their image or all information about them. So like ideally, what do we individually want as a consumer? I'm thinking about credit scores. I would love to be able to simply project whatever image I want to the market whenever I want to, right? That's the ideal for you as an individual. So in some sense, I don't necessarily want firms ever to be able to know what my real credit score is. I simply want to be able to project a credit score of my choosing to them. And it's only because I'm sort of prevented from doing that I have to sort of settle for exposing, hopefully only the good sides of my existence as a consumer. So maybe it's control, like total image control is sort of one extreme in the spectrum, and then the other extreme is, you have no privacy means total lack of control and others can see you. But then at the same time, when we think about, mergers, right? So we have, if two firms merge and each firm has some data about you, is it a loss of privacy that they're pooling the data in the merged firm, or is that a gain of privacy? It's not completely clear to me. On the one hand, yes, I told one thing to one firm and another thing to another firm, and now they can get together and compare notes. So I guess I've lost privacy. But on the other hand, now there's only one entity that has my information. So which is it? This is part of the reason why I'm skeptical that we can really coherently, even bring privacy in as a kind of independent concept in antitrust analysis. I think at the end of the day, the nice, robust thing about the consumer welfare standard is that, we don't have to really have a theory of privacy at all or even talk about it. We just have to look at, what moves the needle on consumer welfare and what doesn't.
Thanks, Ramsi. Koren?
Yeah, I mean, I always try to think, what's to really understand where the agencies are coming from. What's the best argument? What's the best articulation? Do I really get it, right? So that you can have meaningful engagement, sort of where the rubber meets the road. And I think if I understand correctly, if I'm the agency, my anti-competitive theory is just that, especially in mergers, is that this is quality. And so it's, just like if a merger results in higher prices or higher, quality adjusted prices, then that's antitrust, right? I think when it comes to what Andrew was talking about the information asymmetries and externalities and sort of, I was thinking of, markets for lemons, and I'm not sure though how antitrust would solve those kind of issues, right? Not that they're not real problems. And I guess I should have said earlier, it's not that I don't think that privacy is important or that consumers have increased expectation for privacy. It's just that because of this privacy paradox, I'm worried about sort of the government coming in and imposing its preferences or what it thinks consumers want or what it thinks is good for consumers, when consumers in reality are making these trade-offs, right? And I think, one of the theories, and Andrew talked about this earlier, that we've heard a lot is this, that data is a critical input and that you're depriving rivals of it and creating sort of, insurmountable barriers to entry and moats and harming rivals. But I think that if the remedy is compulsory sharing of data, that to me would just raise more privacy issues, right? I don't know how the two work together there. How we can make them work together.
Thanks, Danny, do you want to weigh in on how, how competition, when is privacy competitively relevant?
I'll do it the opposite way of what do I not understand? Because it doesn't quite make sense to me. Two things that I've not been involved in. Number one, the Buddhist cartel on Facebook case. This one is, from an economic standpoint, puzzling. And similarly, um, we are now seeing in Japan abusive superior bargaining position, which itself is weird. But now we're adding it as the privacy aspect is part of this abusive superior bargaining position. So these are the things that trouble / puzzle me. But I think that part of it is also in the opposite direction of like where does it matter? Like, yeah, I mean, like ideas of uncertainty. Like we've seen this on the antitrust side across a number of different doctrines and economic areas, particularly in vertical. Like we know how to deal with that, I think, mostly. Dale is looking at me like, not on the deals that I had to get through. But I think we more or less know how to do it. Like the basic mechanisms of like, oh, do we know how to deal with quality? We've done it before. Again, Dale's like, not on my deals. But I think we know how to deal with that. And I think if it is just another manifestation of quality, shouldn't be a problem. But then there's like the weird stuff. And, when do we deal with the weird stuff versus and decide that actually we want to see more weird? And
I'm all for that. More weird, yeah.
I'll leave it at that then and just say, what do you mean by that?
Well, and can I?
I didn't bring it up. What do you mean by that, Danny?
So there are a couple areas that to kind of go back to the last part of your question, James. There are a couple areas that privacy does potentially rise to a level where competition might have an effect. Financial security is one of those areas where people like to have assurances from their banks that they're keeping a tight grip on that. Political areas. So, there was a big rise in the popularity of Signal and Telegraph, of being these very privacy focused methods of communication. Reputational risk. At the risk of being a little salacious, we had a great case at the FTC against Ashley Madison because they advertised that they had great privacy. They did not. This was if you're not familiar with it, it was a service to allow put together people that were intent on committing adultery. And you can imagine that privacy would be important to the folks that would be
They just moved to Tinder. It's okay.
Right. But the counterexample that I'll leave it with would be perhaps healthcare, because HIPAA was actually designed to allow sharing and to encourage sharing within the ecosystem. And the whole regulatory infrastructure within healthcare really seems to be more focused to be like, no, we're going to get better care if we have better information sharing. Now, there's, of course, a lot going on there, but just let me put that example out there into your heads as a really complex case of like, well, do we want more privacy or less privacy, and how?
Well, I mean, thanks we still didn't get down to what Danny meant by weird, but maybe by the end of the panel we'll get there.
We just talked about Ashley Madison. I think we've hit it.
All right. But one thing that was interesting and that I think came up in a lot of the remarks here was the difference, and I think especially I was thinking of Ramsi with put forward the image that you want to put out there, is the difference between what is sometimes referred to as instrumental privacy versus intrinsic privacy. So the instrumental privacy is I just want to sort of strategically reveal, and it's the control issue. Like I want to put out the face out there so I get the best deal or the best dog at the lowest price, right? The best dog at the lowest price. And in Andrew's case, I would just if we're shouting out for co-authors, I have a co-author who's done work on this, Tesseri Lin at Boston University, have done really cool experimental work on the teasing out the difference. And it turns out that we both care about privacy to get better deals, and we care about privacy because we just care about privacy. That's the intrinsic side of it. So, I mean, it's sort of interesting that we end up hitting on that, because I do think that distinction is quite important, because it's that strategic privacy that can really make markets fall apart. When I want to hide stuff, I want to hide my creditworthiness or my willingness to pay, and then that's when lemons markets evolve. But let's move on. So, Ramsi, I want to turn to you on this question to take the lead. So, and we've touched on this a little bit. If we think about, if let's just go ahead and stipulate that we're going to allow a reduction in privacy to be part of, two firms are competing on privacy. There's a merger, and somehow it raises a competitive problem, and we want to figure out what is the harm. So how do we measure the harm from a reduction in privacy? In normal antitrust, we think about output or reduction in increased price, lower output. In the consumer welfare standard, though, the consumer welfare standard handles both shifts in demand and movements along the demand curve. So it could be quality as well. I'm thinking, in the sense the consumer data it's a little different, because I may lose privacy and you lose utility in the same way that I have and suffer a higher price or lower quality, but the firm isn't automatically getting an increased profit by collecting my data. They have to monetize it. And so does it make the job for the regulator or the court, if it were a private enforcement action, in trying to figure out what the consumer harm is, does that nuance make it more difficult to kind of think through that?
I think it does. I mean, I think it's instructive to sort of think through just traditional consumer welfare analysis in the kind of circumstance that you posit. So, you have a merger. What might be what might be one kind of anti-competitive harm from a merger between two firms that are, let's stipulate that they are, selling a privacy is a component of the products that they sell, and it's a component that consumers care about and value. Okay. So you get less competition to supply this privacy product, and so we would expect that it would be offered at a higher price. And so that's we should be able to see that. And so that would just be a very sort of plain vanilla type of a case. But I think what you're thinking about is, as a result of the merger, the firm provides less privacy. So it's not that it's going to charge more for the same level of privacy. It decides, in effect, to degrade the quality of the product. So in traditional,
it's like a zero price platform, right?
right. And so, so there we're worried about harm to consumers that doesn't come from sort of, if I'm just thinking about this in a very Econ 101 partial equilibrium way, it's not coming from the price going up. It's coming from sort of the quality of the product that's being offered going down. So, first off, if this is a market in which consumers can, care about and perceive privacy levels, they're going to be willing to pay less for the product. They should be, want to substitute to other products, even out of market products. So we might think of it a little bit that way. So you've got a harm to consumer welfare. The price is the same, but the value that consumers are getting is lower. So there's an overall decline in consumer welfare. So that, again, seems to me to be a fairly traditional analysis. But what you're talking about is there's a kind of second order set of harms, which is the reduction in privacy then results in this data being sold to advertisers, and that in turn results in more targeted advertising, potentially for products that are not related to this market at all, and that potentially could drive up. So then the next question is, what is our view of advertising? Do we accept the sort of dominant view today that advertising is primarily informative, in which case there's potentially a divergence between consumer welfare and total welfare effects here, but overall, it's going to be efficient that more data has now been extracted from these consumers and sent to advertisers who can target their products to those who value them the most. So maybe there's not a problem. If you take the manipulative advertising approach, which again was the dominant view until the early 80s, then we have a bigger problem, which is now advertising is being used to manipulate consumers into buying products that they don't really prefer. And so we're going to have a welfare loss and a consumer, both a total and a consumer welfare loss. And consumers may not, it's going to be very difficult for consumers to perceive that there's a connection between the loss of privacy in this market and the fact that they're getting higher prices in some other market in a different part of the economy. And so there, I think there's a real challenge for enforcers if we take the manipulative view of advertising seriously to assess what the consumer welfare effects are of privacy reduction. It's very, very difficult to do because you have all sorts of second order effects. So I'm not sure what the solution is to that, maybe a presumption, but that to my mind is sort of the analytically sound way of thinking about advertising and its harms in the context of the consumer welfare standard.
Thanks, Ramsi, and I want to see if anyone else wants to weigh in on this. How we think about harms, if assuming we had some kind of conduct that reduced competition over privacy, how would we think about measuring the harms to consumer? One other thing that I threw on the table, and both Koren mentioned it in an answer to an earlier question, and something Ramsi just said, is sort of the difficulty, the inherent perhaps subjectivity as I'm an enforcer or I'm a court and have to figure this out. You're having to figure out what are privacy harms, right? In some ways. So I don't know if anyone else wants to weigh in on this question.
Just a quick addition to what Ramsi was saying. It's not just advertising. I think that there's also this question of the ability to price discriminate that I was I think alluding to. It's, I think there's a sense among some of the regulators that for a given level of competition, the ability of consumers to bargain for a good deal, that the share of consumer surplus that they would get is lower because the ability of the firms to manipulate or just extract consumer surplus is higher. Whether that's true or not, and what situations that might be true is I don't have a good answer to that, but I just wanted to broaden the preview a little bit. It's not just advertising; it's also in terms of the bargaining and that individual.
Emphatically agree with you on that.
And I'll plug a paper that I did, many years ago with Luke Frobe and Dan O'Brien at the FTC called Competitive Spatial Price. It's about competitive spatial price discrimination. It's exactly kind of this is 2005, so pre-Google and DoubleClick merger even. But the idea that, it was in the Antitrust Law Journal, so it was a law review piece where we took some of the existing IO lit on this very idea that if you, at least theoretically, had the relevant information, more information could allow precise targeting and actually create a duopoly, what would be kind of a duopoly market into something that would be competitive, because in theory you'd have a bidding war for every individual consumer. I mean, that's in the limit. But anyway, I digress to self-promote. So go ahead.
Actually, if I can just jump in very quickly, because
Sure.
I think there's just a very elegant way analytically to think about the connection between the price discrimination and the advertising, which is the targeted advertising, to the extent that it's manipulative, right, is chipping away at consumer welfare from the demand curve side, from the value side, and the price discrimination is from the price side. So information affects both of those.
Danny or Koren? I saw Danny look like you're about to jump in. No?
I'll say something anyway.
Okay.
When you're sort of thrown, like you have something to say, sure. So
You just have one of those faces. You look like you're ready to go.
So, if we're thinking about adding more things, what's a good way of knowing that there was a privacy harm? I'll go with, to me, the most obvious one. How about a data breach, right? Your personal information, your name, your email address, maybe even your social security number, ends up on the dark web. I think we can all agree that that's bad.
But is it a harm?
Is it weird?
So then this gets to the consumer protection side, right? We would say, wait a second, right? It's there. And then the question is, but what's the economic harm unless someone's used it?
Well, go ahead.
Yeah, no. So I was actually setting up, because I know that this is an area that you've also been involved in. So like we're constantly told, aha, we have these really neat little analytical tools. When you sit and go through it, they're not so easy. And then actually I was going to really bring it back to you, but I thought, do we have enough time? I'm like,
Like, what, who cares, right? That's what.
There's always more to say. I mean, as an economist, what are you willing to pay for it, right? If you pay $1,000 to a insurance person, and instead of getting you fire coverage for your house, they go off to Vegas and blow it all on the tables, and your house doesn't burn down, are you harmed? Well, I mean, the question is, what would you have paid to avoid that additional risk, right? If you were to re-roll the dice, what would you pay to at that point? That's really hard to measure as part of the problem. But I would certainly argue that whatever additional risk there is of your data getting on the web, which may be zero, given how many breaches there are, how much do you value that? How much are you willing to avoid the risk that might come from that? That's not going to be zero in general.
So, Koren, I didn't want to leave you out on this. One thing that, and I do want to, I have a move on to privacy defenses, but one thing that was interesting with Ramsi's framing of sort of these ripple effects that may go throughout other markets, whether it's, increased targeting in other markets, because I now have data, is the issue of out-of-market efficiencies and antitrust as well, which, is, again, it kind of raises another interesting legal, where sort of the law comes up against the reality of what you can add and what you can subtract. But Koren, let me move where we are going to run out of time here. It's been great, but I want to move now kind of, we've been talking about how would we, as is either private as an enforcer or a private plaintiff, deal with privacy where as an antitrust harm. But here I want to switch it a little bit and talk about privacy as a defense. So we've seen this more recently. I think most famously in the Apple Epic case, where Apple said, "Look, my App Store." The strictures on payment have to do with privacy and keeping a nice ecosystem that's free. We've seen this in the Google Privacy Sandbox issue, where Google is unilaterally trying to say, okay, we're going to deprecate cookies and we're going to come up with new ways to track, but also privacy centric. But the CMA in the UK is, forced them into into signing a kind of a consent. They have a special term for it, but it's essentially okay. But we're going to watch you and see what the competitive effects are. You've also seen this in the state and private cases against Google with ad tech, that there's an allegation that through the real-time bidding that consumer data goes through, and one of the opinions in the motion to dismiss in one of those cases, the argument was, and the judge agreed, is like, well, this is we don't share this data with competitors because it is privacy. It helps our consumers' privacy, right? So, we've seen instances where privacy has actually been used as kind of a shield, as opposed to it being used as a sword. So, to what extent do you think that privacy is a valid defense in these, and like kind of what are the limits of that?
Sure. So, I think it's highly fact specific, right? It's going to come down to what your documents say and the pretext. Or is it really a reason? I think I mentioned earlier in the panel, there's the case where someone says, I'm designing my product in a specific way that's going to deprive rivals of data because I need to in order to comply with the California privacy law or GDPR, something like that. And while I'm not aware of case law specific to complying with the privacy regulation, there is case law. For example, a recent First Circuit decision that kind of collects cases saying that in an antitrust case, complying with another law is a legitimate business justification. So then the second kind of area is what James was talking about, Apple's kinds of defenses in the Epic case. And here is where I think out-of-market efficiencies do really come in, right? So there, the Ninth Circuit affirmed, agreed with the lower court's decision that Apple's privacy justifications were both non-pretextual and were cognizable. And the Ninth Circuit rejected two of Epic's arguments. First, Epic and its amici argued that, well, protecting your device security and privacy for consumers is a social goal. It's not antitrust, right? And relatedly, even if it's an out-of-market efficiency, right? We're talking about a relevant market harm to developers, and you're talking about a benefit to consumers. And so the court went to kind of great lengths to say, well, protecting privacy and device security was about product differentiation, which therefore increases interbrand competition, which is what we really important to antitrust, right? So they said there was evidence that at least on the margin, Apple has more privacy than Android, Apple costs more than Android, and people can make choices, right? And this is good interbrand competition. To me, I feel like it's really, and then on the out of market, they said it's not out of market because there's a couple ways you can drive demand to the App Store, and one of them is just have more people buy the iPhone to begin with, right? So it's not out of market, it's in market. I sort of wish, like, why do we have to do this, right? To me, a legitimate business justification should be a cognizable one, protecting user privacy, right? Like, but here they were sort of saying, well, for it to be a pro-competitive, rationale, it has to benefit. It can't just benefit Apple. It has to benefit and consumers. It has to benefit the sort of competitive process, right? And that's not typically what we see in Section 2 case law, at least, where usually if the defendant has a legitimate business justification, we go home. And then the other thing with the privacy sandbox, I'll just briefly, my firm does represent Google, not in the privacy sandbox matter. So what I'm going to say is just based on publicly available information. But I think that it's, pro-competitive to respond to demands or respond to criticisms that consumers don't know what kind of data they're giving over. So, the other thing is that, with all the, people claim, well, it's pretext, right? They don't really care about privacy. It's just all pretext. But I think the fact that firms without any alleged monopoly power, firms without the ability to exclude or harm rivals, also are taking similar actions is a very strong indicator that there's legitimate reasons to do this, having nothing to do with with trying to exclude.
Thanks, Grant. So does anyone else on the panel here want to weigh in on the use of privacy as a defense? I thought, Koren, you brought up an interesting nuance there about, as opposed to, in the it's a business justification, let's go home, as opposed to, no, it's got to be a business justification that enhances interbrand competition, which kind of gets back to the idea of when can privacy, is it privacy per se for consumers, or is it have to be some kind of nexus between competition causing privacy or reducing privacy? I don't know if anyone wants to weigh in. Ramsi?
Sure, yeah. So, I mean, I think that they're looking at this from a consumer welfare lens. There's sort of, legitimate business justifications, which are really about kind of, giving the court a sort of intuitive argument for, for the fact that the behavior improves consumer welfare by improving the product. That's basically, if you try to sort of understand all of antitrust from a consumer welfare lens, that's how you have to understand legitimate business justifications. It's, hey, pointing out to the court that this actually makes the product better, and the implication is that better in the sense that consumers value it more, and so that's why we want it. And I think, arguments about privacy that are in that vein are totally legitimate and good and helpful. But, we need to be careful, because if we make arguments that really aren't about sort of giving a court an intuitive sense of why this is actually consumer welfare enhancing, we're simply treating privacy as a kind of independent value in itself, then we get to this problem that I pointed out initially in my remarks, which is, if we're now going to start importing sort of independent values into antitrust, why stop with privacy?
One thing I just wanted to add
go ahead,
quickly
Koren.
is that I think that with product design, it's different. It's even more important to be more deferential to a company's, as long as there's support or not, evidence to the contrary in their documents that this was truly the rationale. Courts have been really clear that courts are ill-equipped to judge product design. And so many circuits have come up with tests that are quite difficult to meet for the plaintiff, right? So some tests that say that as long as there's, some benefit and the sole purpose wasn't to exclude, then we're not going to judge product designs. So I'm worried about kind of requiring more instead of just evidence that it was a good faith justification, in a way that they were trying to compete and trying to satisfy consumers.
Danny or Andrew, you want to weigh in on this?
I have just one very quick point, which is I always find it fascinating. Agencies like to focus on out-of-market harms. Companies like to focus on out-of-market efficiencies, and they both complain why they can't get what they want. This is just another manifestation of that. And it just suggests to me that it's hard for judges, it's hard for agencies, and it's going to be very fact-specific in a lot of cases where I don't think we do have very easy rules that we can use.
Andrew, you anything to jump in there on the
Uncharacteristically quiet on this one.
uncharacteristically quiet. I like that. All right, so I like that because we're running short on time, and we have one more question that I do think is really important that I want to get to before we get to the audience questions. Is kind of the other way, the flip side that we haven't talked about yet. We've spent all this time talking about antitrust and competition, and how does competition affect privacy? Privacy is a defense in competition, but there are a lot of privacy regulations out there. I think Koren talked about that, and with complying with if you're complying with the regulation is actually a legitimate business justification. So there is empirical evidence. Actually, Leah Wogman and Ginger Jin and a co-author whose name actually escapes me.
Last name is Gia.
Gia. Okay.
First author.
Yeah.
But let me be clear. Both Liad and Ginger are my co-authors too, so these are the names I remember.
Okay, so I anyway, Lee, they have a series of papers that show how GDPR has had kind of a negative impact on competition. I'll shout out to another one of my co-authors, Garrett Johnson up at BU, who's done a few papers that have talked with various co-authors, Sam Goldberg being one of them, that also show sort of a negative impact. GDPR, not surprisingly, I think it was alluded to in the DMA panel, who can. Big companies are probably more likely to be able to deal with the GDPR than small companies, and so you've seen some competitive issues there. So, Danny, let's just what do you think about the other way?
So let me just start by saying I have a forthcoming paper. It's open access. Journal of Economics and Management Strategy, where we sit and look through across all econ and the adjacent fields that really cover this issue empirically in platforms over 20 years. We ultimately came up, and we were very generous with which econ journals to include relative to, say, a marketing journal or IS or strategy, for example. We had roughly 860 papers, and quite a few of them dealt with this privacy issue. So we do have an empirical record. Here's the interesting thing. Specific to GDPR, there's literally not a single paper. Right now there are 12. No, actually, as of last week, there's a new NBR working paper involving cloud and privacy and GDPR. There are now 13 papers between published papers like Ginger and Liad's that was in marketing science. There's not a single one that shows that GDPR benefited competition, not between published papers and top journals or even just working papers. That's really bad. But if we look beyond the GDPR context, and again, we can look at some of Garrett Johnson's other work. We are finding that there is a tension between privacy, regulation, and competition. Now, how we measure competition varies across papers, but the different ways, including innovation effects. That's my favorite working paper, Joel Waldvogel and co-authors. I don't remember who the others are. Shows that, literally the number of new apps is down by 1/3. I mean, this is some serious stuff. And the work pretty much only goes in one direction, bad. So there are probably vignettes that we can give about why we're not seeing other kinds of work, but I want to be very clear from the empirical record. It is not a happy coexistence between privacy regulation and competition.
All right, on that pressing note, Andrew, you want to, or Koren, I'm sorry.
One quick note, and then I'll turn it over to Koren. There was, my memory is there's one paper, there's a follow-up paper by Acquisti and some co-authors, and he wasn't the lead author on it, so I apologize to his co-authors. But again, it's the name that sticks in my head. They did a follow-up so Garrett Johnson and his co-author just published this paper, I think a couple months ago, finally, after it's been out for a while, showing that immediately after GDPR, the kind of ad ecosystem collapsed, and like the number of firms in that ecosystem just plummeted. This follow-up paper suggests that some of that ecosystem has come back. It hasn't improved competition necessarily, but I did want to say I think there's a little bit of nuance there. Now, the other kind of fun fact of that is there's also a suggestion that maybe it came back because enforcement isn't so great. So if you have a regulation and you don't bother to enforce it, maybe it won't have an effect on competition. Sorry, go ahead.
It turns out that consent rates on GDPR are actually extraordinarily high, like 90. Everyone thought they opt-in would mean you don't have data anymore, but they're close to 90%, which leads to another, as I understand it, it's perhaps skirting the consent requirements, and that's something they're getting to. But anyway, Koren, I'm sorry.
Well, I know we're almost out of time, so I'll just pose this as something to think about for the panel and also this audience. How do we, persuade Europe and other agencies about this? It seems like if the evidence is clear, I know I had this in the standard essential patent context where we had so many excellent empirical and other papers. And I remember presenting once to DG Comp and them saying, oh, but that was written by X and X. And so we don't, I'd say, well, it was an empirical paper. Like, would you like the data? You can rerun it yourself, right? It dismissed because that person had done work for my then company. So, what can we do? Are we having the right authors? Are there ways in which we can explain these are the unintended consequences we've been warning you about in a natural experiment kind of showed? And so, like, can you be careful in other areas too?
Ramsi?
I want to hop in and just add quickly that, whether the fact that regulation is reducing output in advertising markets is good or bad for consumers is going to depend on your view regarding advertising, right? Whether you see it as informative or manipulative.
So we are getting close to time, and so we've had a great discussion up here, and we could probably keep it going, but I definitely want to open it up to the audience, which I'm sure has questions. I hope they do, so I don't have to cold call on anyone. I will. I'm ready to. But anyway, so questions?
Is that an auction sign, or is that
I'll pay $10 for you to stop. I see a hand up here.
Hi, my question, Ethan Yang, I'm a student here. My question's on sort of I know it was mentioned that the Europeans think differently on privacy and the Americans think differently on privacy. So I guess if we're defining like how does privacy fit in consumer welfare, do you think that the Europeans actually do think differently as as citizens, or is this more like the EU, the actual bureaucrats imposing that preference, right? So where do you think, do you actually think that these preferences are different across the world? And if so, why do you think that is?
Yeah, I mean,
Who's the most European up here?
I mean, I've had a number of conversations with people, not just regulators, in Europe. I've seen a wide variety of papers written, and it seems to be real. One of the distinctions people talk about is that there is a greater comfort for, say, governments having your data versus companies in Europe, and that's flipped here. And so those cultural differences do seem to be real. How much is also driven by, sort of path-dependent regulation? I don't know, but there's something there.
But you get to a good point, about survey design, right? So when I was here at George Mason, I think James and I and John and several other of us did a comment to the European Commission on a survey that they did that asked questions like, do you like privacy? Do you want privacy? not like in any trade-offs. Do you want, in exchange for, are you willing? It was literally like, do you like privacy? And so we did a survey kind of explaining, how to do samples, how to write questions. And it wasn't even open-ended. It was like, yes, no, maybe. And so, the survey design matters, right? Obviously.
Did you have a I don't know?
We did put in a lot of you should have I don't knows, but mostly it was like a lot of the questions were quite leading and just, I mean, yeah, I guess I like the color red, but, or do you want it like for a bow on my head or I don't know.
So we've also seen some really interesting empirical work with locational tracking data, particularly during the pandemic. And it turns out there are certain countries that seem to be willing to give more locational tracking data. So one is Taiwan, and we could understand why. Tough neighborhood. We'll just leave it at that. And other countries that live in tough neighborhoods also seem to be okay with giving locational data. Countries not in tough neighborhoods, although since that time we've had a series of events, but at least snapshot 2020, 2021. Other places were less willing to give this kind of data. And in part, it's because they didn't like the results that people found. So if they didn't give the data, it turns out the telecom companies have it. So lockdown in Italy actually meant that only slightly more than half the people in lockdown were actually following lockdown. They didn't want that information coming out for other reasons. It is largely dependent on country, culture, and to a certain extent, the regulatory environment, and how much of it is because you live in a tough neighborhood.
I think Judge Ginsburg has a question over there.
Well, I'm questioning what Professor Woodcock said about whether it's a good or bad thing that there might be less advertising depends upon individuals or the public's taste for advertising. That seems to me rather incomplete because it would depend upon the public's taste for advertising and advertising-supported content. The less advertising, the less content. So when people say, well, I don't like advertising, I don't think it's a very useful answer because they may say, well, I do like content. And if that means less content, then no, I have no objection.
So, I think it depends on. There's a whole sort of separate question of how we should fund our public goods, and yes, in America we do fund a lot of our public goods through advertising. Often consumers aren't completely aware that they are paying for the public good through the advertising that's served up to them. To my mind, there are better ways and more democratic ways to pay for public goods through advertising. So to my mind, that's a separate question. That's the public goods funding question. But if you take issue with that, feel free to cabin my remarks to markets in which advertising isn't being used to fund public goods.
But how is like the New York Times a public good? How is Google a public good? Right? To me, I think he's saying like people, if you want things that aren't behind paywalls or subscriptions, like it costs money to make things. And so the advertising is allowing the content on the web or, yeah. So what do you just think is a public good?
So I think access to journalism is a public good. I think in general, we're not willing to pay enough for high quality investigation, journalistic investigations. And so advertising is used as a way of sort of making up that gap. But there's other ways to approach that. I mean, the traditional way of dealing with public goods is through taxation. To my mind, advertising, if you take a view of it as manipulative, is a highly inferior approach to funding public goods relative to taxation. I realize we're getting a little bit off topic.
Yeah. I mean, this is what this is. It's getting weird, which is what I like. Anyway, I think we have time probably for one more question. There's got to be one more question. Oh wait, Mr. Robertson, I wait for the mic.
Gabriel Robertson. I'm also a student here. I thought Ethan had a really good question earlier, but I would ask the flip side of that question, which is why do we presume that the American public is not also sort of path dependent based on the lack of privacy law and how those preferences aren't necessarily secured by the appropriate legislation?
That's always going to be a question. What is organic preference versus path-dependent preference, right? I mean, that's an impossible question to ask. I think the right way for me to look at this is to have a very clear-eyed view of the costs and benefits of, what is it that we're trying to do? With any kind of regulation, if we're still talking about that space, what are we trying to accomplish? And are we targeted, both are we grappling with the costs that are inherent in any kind of regulatory response that we have. And certainly I have been personally worried that a lot of the conversations that we've had, I guess in the US, there's been less progress on this, but a lot of the conversations we've had in regulatory spaces have not been clear about what those costs are. I think the content issue that Judge Ginsburg raised, I've written a paper, I'll get one plug, I guess, right? So it's a really hard question. You don't know. But what we try to do, I think, is to say, okay, regardless of where we came from, what do we gain from regulating? What are the costs of that? And are there ways to adjust that balance to get more of the benefits and less of the cost?
I mean, I think I would just add that when you think about path dependency, I think here in the U.S. we'd have to go back to the Constitution because, I mean, the First Amendment is something that's different here, and whether that carries forward 250 years, but the Supreme Court, of course, said that advertising, the right to say it, but more importantly, the right for consumers to hear it, is protected under the First Amendment. I think it's a great question, right? But is that path dependency going back? Is there just something different in our DNA over here, or is it just the way from where we started back 250 years ago that the idea of a free flow of information has just been ingrained in our society? I don't know the answer. I think it's a fantastic one, and so maybe a good way to end, because I guess we are out of time. So let me again join me in thanking our panelists for a great discussion, and then we'll convene in there for the rest of the day.